And thirdly, we talk about protection, right? If you come up with a solution, what do you do next? You need to protect it. So what are the things you need to do to file a patent? Okay, so in order to file a patent, you have to meet three criteria. The first criteria is, of course, you have to have an invention first. It must be a technical invention, yeah, a technical solution to solve a technical problem. That's the first requirement. The second requirement is you must have an invention which is new, meaning the combination that you introduce is something that is not found outside. Yeah, you may have, in the case of 3M, paper is already out there, glue is already out there, but no one has combined them together in a new combination. So this combination must be a new combination, uh, and if it's in certain countries, you have the 1 year grace period. Even though you sell that product to the market, then you can still file an invention, it's still considered new. But beyond that 1 year grace period, the invention is not new anymore. So your invention is considered new if your invention is not in the prior art. So if you want to file a patent, the first thing you do is you have to search your prior art to find out whether your combination is new. You may do a patent search, you may do a internet search, you may do a journal search to see whether the invention is actually new. So that's a requirement, right? Because your invention has to be new. So you have to be careful. If you come up with a good solution, a solution that the market wants, you have to make sure you don't expose it prematurely. Yeah, if you expose it prematurely, you will destroy your own novelty and your patent, your invention become non-patentable. That's a requirement for you. Yeah, do not expose it prematurely by sharing it in your Facebook or write it in your journal. All this will affect the novelty of your invention. The second requirement is your invention has to be inventive. Yeah, the combination has a synergistic effect. So if it has a synergistic effect, it's inventive and it's patentable. That's the second requirement. What is synergistic? You know, if I were to present it graphically, it means you add in something, additional element, the result become better than expected. There is a jump in the effect that you can get from your combination. That's what is required for invention. And thirdly, is something workable, something that is not just a theory, it's not just a concept, but it works, right? So these are the three requirements. So this is an example of a patent filed in US in 1805. Someone just combined pencil and eraser together into a new product. So they want to file a patent in US in 1805. So this patent, is it new? In 1805, no one has combined pencil and eraser together. It's new. Is it useful? Meaning you can practice? Yes, you can actually use it and work, right? It's useful. But whether it's inventive or not, you need to make sure that there is a synergy combining the two together. In this case, synergy comes in when you put the eraser and pencil in such a way, you can actually customize the eraser to the pencil, right? So you use 2B eraser for 2B pencil. So that is called inventiveness. There's a synergy to just standing alone when you put together. So that invention was actually patented in US in 1805, right? So these are the processes of you filing a patent. You do a novelty search using the big data. You need to draft a patent and you need to file the patent, and the patent will go through examination. And if you intend to file in overseas, you have 12 months for you to file in overseas before the patent is examined and granted. And after the patent is granted, you will need to renew it on a yearly basis. So this is the procedure of a patent. And this is the life of a patent, right? Once you have an idea, you have an invention that solves a real problem, and it's potentially going to sell very well. So before you sell it, before you expose it to the market, you would need to file a patent. And once the patent is filed, it is called patent pending. During the patent pending, you can't take action yet because it's still a pending right. But a patent will take some time, 2 to 4 years, depending on the country. Singapore nowadays, you can get a grant within 6 months, right? That they have a fast track expedite for grant. That's the fastest in the world. But normally you take 2 to 4 years for a patent to be granted. Then after the patent is issued, it is effective from the day you file for 20 years. The patent is effective retrospectively from the day you file for 20 years. So during that 20 years, if someone would copy your invention, when it is still patent pending, you can still take action against them because the patent is valid from the day you file. So that means, once you file a patent, you can sell already. You don't have to wait for the patent to issue before you sell your product because it's retrospective uh, uh, validity, right? So what does a patent do? Yeah, once you have a patent, you have the right to exclude people from taking your combination and manufacture it, or people taking your combination and use it in the factory. Even though someone just import from other country and use it in the factory, if they use your combination that you have patented, it will be infringing your patent. Or someone selling or importing that combination that you claim into the country where you filed a patent, and the protection is defined by the claim that you have for 20 years in country where you filed a patent. So if someone were to use your combination, you can sue, or if if you want to commercialize it, you can license your IP, your combination to the world in returns for royalty. That's what you can do with a patent. Okay. So because of time, I have no time to go into every slide, but to share with you, when you look at the patent, you have to pay attention to the claim because this is what you own, right? So you can have broad claims, you can have narrow claim. If it's narrow claim, people can bypass you easily. If it's broad claim, then you have more protection. Very quickly, I will just share with you, what we mean by broad claims and the narrow claims, right? Like for example, you have a bicycle, you have a unicycle, right? You have the conventional prior art is you have a seat with a wheel. That's 1800, right? No one have bicycle yet. So you are the inventor. You come up with a bicycle. So you have A, B. You add in a tire at the back, C, and you put in a wheel. You put in a steering wheel, a steering in front. Then you have this combination of A, B, C, and D. So if you file the patent this way, A, B, C, and D as your claim number one, then competitor can study your claim and try to bypass the claim by changing the D to a E, right? So if they do it this way, the patent, if you claim your patent narrowly by putting A, B, C, D in your claim one, then your patent can be bypassed if people change one of the elements. So in order to extend the protection, make it broader, you should claim only the essential element, which is A, B, and C in your claim one, and D as your claim number two. If you do that, then your patent becomes wider in terms of protection. So this is what we mean by broader claim. So it is important how you draft your claim. How you draft your claim will determine how wide your protection is, right? So this is what I would like to bring to your attention.